on IPR organized by IQAC IPR Cell of Bhavna Trust Degree College, Devnar. With the blessings of our founder trustees, late Shri Keshavji Chadwa, late Shri Gagubhai Chadwa, late Shri Mulji Nisar, late Shri Praveen Chandra Dalal, and late Shri Damjibai Ankarwala. Currently, our source of inspiration are our chairman, Shri Jayantilal Chadwa, our trustee, Shri Nirmal Kumar Chadwa, Shri Premji Nisar, our managing trustee. Our college was established by the stalwarts in the year 2003, has a prime benefit, that is locational advantage. We are right in the center of Harbour, Western and Southern Mumbai, and a huge residential zone which reduces considerably the commuting distance to attend the college. The courses offered in our degree college are Bachelor of Commerce, Bachelor of Computer Science, Bachelor of Information Technology, Bachelor of Management Studies, Bachelor of Accounting and Finance, Masters of Commerce, MSc IT IDOL. Inventions and ideas can transform the future forever. All innovations begin with a simple idea or a thought. From a simple thought, an idea can be built upon and developed into a fully functional invention, making life easier for human race. Today, more than ever, an idea is worth far more than its face value. Here comes the importance of intellectual property rights. It is a need of the hour to create awareness about the process related to the IPR among the academicians, research scholars, students, and entrepreneurs. This webinar is intended to cover various aspects of intellectual property and the rights associated with it. IQAC IPR Cell of Bhavna Trust Degree College, Devnar, have taken the initiative to organize this webinar to provide an insight about intellectual property. For a live audience, I would like to say, if you have any questions regarding this topic, you can type in the chat box after the guest speech. We will take up your questions for further discussions. So, let us start our program officially with the blessings of Goddess Saraswati. Now, I invite our principal, Dr. Mrs. Aruna Singham, to welcome the audience. Over to you, ma'am.
Thank you, Rupali. Good afternoon, everyone. Welcome to Bhavna Trust College's webinar on IPR. I am very happy to see that in a very short period of time, many of you have joined this webinar. Today, we academicians are living in the era of research and innovations. In order to start with any research and innovations, I think exact knowledge of related laws are mandatory. So I thought it would be appropriate to conduct this webinar as it is the need of the hour. So for today's webinar, we have invited Mr. Sajid Sheikh from NLU Mumbai. Sir has got his expertise in the field of IPR. I had attended one seminar of Sir that was very fruitful. I am sure that you all will be benefited after this session. So without taking up much of your time, let's start with the function. Thank you once again, everyone. Rupali madam.
Thank you, ma'am. Let me introduce today's speaker, Mr. Sajid Sheikh. Sajid Sheikh is one of the founding faculty of National Law University, Mumbai, and is serving there as an assistant professor law and coordinator of Center for Research in IP. He obtained his LLM honors specializing in intellectual property rights from the National Law University, Jodhpur, and is pursuing his PhD from Nalsar University of Law, Hyderabad. With Center for Civil Society, a leading think tank, he prepared a compendium on repeal of laws for the state of Maharashtra, which was submitted to the government. For his achievements in legal field, he was recently interviewed by Super Lawyer, a leading legal portal. The NGO Lawlex, in his initiative, which effectively works in the field of legal education in India. His valuable contribution to various law journals and informative lectures on intellectual property rights at various workshops organized by Jammu and Kashmir government, NLSIU Bangalore, Gokhale School of Politics and Economics, IIT Bombay, and other schools are worth recognizing. On behalf of Bhavna Trust Degree College, we welcome you, sir, for today's webinar. Now, I would request you, sir, to start with the webinar.
Very good afternoon. Am I audible, sufficiently audible?
Yes, sir. Yes, sir.
All right.
Yes, sir.
Greetings, everyone, once again. I'm very grateful that, Dr. Aruna Singham, ma'am has given me this opportunity to speak about a very important topic, that is intellectual property rights. I also thank all the esteemed trustees of Bhavna Trust College for organizing such a program. As you're aware, and Dr. Singham just said, that knowledge and about intellectual property, in these very times, in this very era, it is required for everyone, be it academicians, be it students, even be it laypersons. So we all, in some manner, keep on creating, keep on innovating. So we have to have information about intellectual property. Even there are NAC guidelines, UGC guidelines, National Intellectual Property Policy of India, which talks about IP awareness, capacity building, so on and so forth. So, dear participants and dear friends, today, this session will be an introductory session about the intellectual property rights. I have a short presentation which I'll just share. And in case you have some questions, please feel free to ask as instructed by the organizers. Put the questions in the chat box so that I can take those very questions towards the end. Is the screen visible? PPT visible?
Yes, sir. Yes, sir.
So, yes. All right. So in front of your screen, there is a small cartoon which talks about a relationship between various variables. For example, copyright law and art, which says like art would not exist without copyright law. Inventions would not exist without patent law. Land would not exist without real estate law. The point is that in order to protect a subject matter like invention, like art, like land, there is a need for laws. And these laws, how they protect a particular intellectual property and why it needs to be protected, we'll be discussing in today's presentation. Dear friends, we all know about the term property. Some of the property we also own. And we know about tangible property which we can touch, which has a physical form, which is either movable or immovable. Movable property is like a pen. I can move it, right? Maybe notebook is a movable property. But on the other hand, we also have immovable property, like we possess land, we have buildings. These are not movable because they are fixed to the ground. This is the kind of property we know. But another kind of property is the intangible property, which cannot be touched, which does not have any physical form. And these are the properties which we discuss under the regime of intellectual property rights. The examples are like literary works. Okay, for example, I'm having a book in my hand. Okay, this is an example of an intangible property. But you will ask me this very question, sir, this book has a physical form. Then why it is intangible? Why are you saying that it cannot be touched? Dear friends, when we talk about literary works, it is not the physical form of the book which we are questioning, which we are talking about. We are talking about the content which is there within this very book. And this content is intangible. The concept behind the inventions, that is intangible. And those are the creation of human mind. Therefore, if we have to define intellectual property, IP is the creation of human mind. It is the creation of human intellect. It is the intangible property, which is protected by the virtue of IPR. Now, there are two things which I've discussed. One is the intellectual property. Another is the intellectual property rights. Now, intellectual property, of course, as is visible on your screen, is the creation of human mind. But, for example, literary works, inventions, these are the creations. But rights over these very creations are called as intellectual property rights. So, right over an IP is called as the intellectual property right. All these IPs, they are negative right. Now let me briefly talk about what is a negative right and what is a positive right. For example, right to food versus right to life and liberty. If I say you have right to food, what does this mean? It means that you will get some food to eat, isn't it? But if it, it means that you are getting something. But in another example, when I'm saying you have right to life and personal liberty, are you getting life? Am I giving you life? No, there is a life which you already are having. This right to life means that no one else can take away your right to life. Okay, so therefore, right to food is a positive right because you are getting something, whereas right to life is a negative right because you are not getting something. You already have that very thing, but everyone else is being excluded from taking away your right. Similarly, intellectual property rights are negative rights, okay, because everyone else is excluded from infringing your right. For example, copyright, I'll be talking about some types of IPRs in my slides. For example, copyright, because I took this example because all of us, are studying something, have studied something, are academicians, we know about copyright. Okay, if I have written something, who should have the right over it? Of course, I should have that very right. But it's a negative right because everyone else is excluded from taking away that very right of mine without seeking my permission. Now we are living in a knowledge-driven era, knowledge-driven society. Whenever we research something, we find out about some articles. We are barred by the paywall sometimes, and when we are barred by that very paywall, we feel that no, IP should be free. Nothing should be paid. Like we should not be required to pay for reading a particular article. We should not be the all the OTT platforms which are there, they should be free. Well, we all feel in that very manner. We say because this is a knowledge driven society, knowledge driven era where knowledge spreads by reciprocating, sharing, so IP should not be there. So this is a very fundamental question, why IP should be protected in the first place. And I will take help of certain theories. Through the help of these very theories, we'll try to justify that there is a need for a protection of intellectual property. Some of these very theories, of course, are available. There are many authors who have written in detail about these very theories. One of the theories is utilitarian theory. I'm sure you must have heard in some manner about this very theory. This was propounded by a very famous scholar, Jeremy Bentham, who advocated that protection must be granted to a thing if it leads to the greater happiness of greater number. Greater happiness of greater number. He said that something should be protected only when it leads to happiness in the society. Larger number of people in the society should become happy because it is leading to social welfare. So he advocated welfare-centric activities. Now, if we apply the concept of IP with this very utilitarian theory, what we'll find is that, for example, during the COVID era, there was a need of vaccines, there was a need of medicines, okay? And when vaccines were developed, when vaccines were innovated and came to the market, people became happy. Why people became happy? Because their ailments were being cured. They were getting some protection from their ailments. Similarly, if a new mobile phone or new device comes to the market, people become happy. The society, there is a welfare of the society which is happening, and that is why, my friends, IP should be protected. There is another theory, labor theory, which has been propounded by scholars like John Locke. And labor theory is very simple. Earlier, long ago in ancient era we are talking about, everything was available as a natural resource, okay? land was available, materials were available, elements were available. And if someone, that is called as everything was available in commons, means everything was available freely. And if someone invested his labor upon that very thing of something which is a natural resource, he should get, and he was getting, the fruits of that very labor. For example, if I have taken sand on mud and I have created a house of that, who will own by virtue of this labor theory? It is me, because I am the one who has invested my labor. And of course, this theory, if applied to intellectual property, holds true. Why? Because, for example, for example, you have written a book, you have written an article. Who should get the right over that very article, what of that very book? Of course, you, because it is you who has spent, sleepless hours, sleepless days, nights, months altogether in order to come up with that very book or to come up with that very article, isn't it? Therefore, as per this very theory, IP should be protected. Why it should be protected? Because it is the creator who is investing his labor upon his creation and is building that very creation. He should get the fruits of his labor. Now, uniquely, I just want to briefly discuss one theory which is a subpart of the utilitarian theory. It is called as the incentive theory. This theory says that intellectual property rights or IPR protection is a kind of an incentive which is granted by the government over the intellectual property which has been created by a creator. Now, a very famous example which is coming to my mind, about which I read 1 year ago, that there was a drug, a very unique drug which was created, which cured rare genetic disorder in infants. And the cost of that very drug was 18 crore rupees for the single dose. Okay, you might not believe, but this is true. 18 crore rupees for single dose of that very drug. That was the cost of that very drug. But if we bifurcate, if we say, because now I'm sure that some of you will advocate, no, access to medicine should be there, medicine should be free. Who will afford this medicine? But if you go deeper into it, it took maybe 7 to 8 years of research, development, investment of time, money, efforts, labor of the scientists, and then they were able to create that very drug. And if that very drug is allowed to be reproduced free of cost to everyone, what will happen? No one else will ever dare to create that very drug again, because then the person will think, there is no benefit for me, koi faida hi nahi hai mera. Why should I invest billions of dollars into development of a drug which, if I'll bring to the market, everyone will reproduce without my permission? Okay, so that is why the incentive in the form of protection of the IP is required, is granted, and if that protection is there, what will happen? Protection hai, people will not be allowed to use somebody else's invention or creation without that very person's permission. Usse kya hoga? That very person who is the creator will be able to monopolize, will be able to commercialize his invention or his work. A commercialization will happen. Of course, he will be able to reap some benefits, of his creation, right? Now let us talk about personality theory. Personality theory has been propounded by scholars like Hegel and Immanuel Kant. Now they say whenever we create something, we are giving away a part of our personality into our work. What is that very personality? Kaise ja rahi hai? When we say that we are creating something because of our talent. Okay, we are investing, putting our talent into a work in order for that very work, in order to create that very work. Our work depicts our personality. there are painters, there are singers, there are lyricists, there are songwriters. They write or they create in a particular genre because it is their reflection. And who should own a part of my personality if I am the creator? Of course, personality is my personality. I should own that very personality. That is why IP should be protected, because it is the personality. If I am the painter, I should get protection of my painting because it is my personality. Interestingly, a new theory also has developed, which is called as the social planning theory. You can find it in the writings of Professor William Fisher, who is the professor of Harvard University. And Professor Fisher says that IP helps in the creation of a just and attractive culture in the society. Now, kya hai ye just and attractive culture in the society? I'll use the same examples. Everyone wants new kind of luxury items, good looking items. Everyone wants their ailments to be cured. Dekhiye, simple example I'll take. Why do you think a lot of innovation is happening, firstly, in the realm of anti-cancer drug? Secondly, with respect to anti-COVID medicines and vaccines. क्यों ऐसा हो रहा है? Because IP is society driven. People want, when जब IP आएगा ना, people will become happy. When new technology comes into the market, it solves the age old problems. आप लोगों ने शार्क टैंक देखा होगा. The sharks, they say, we want those such inventions, such products which solve some problem. So IP solves that very problem. Intellectual property solves that very problem. And it creates a better culture. So there is a demand, which demand is met by the virtue of intellectual property. Our ailments are being cured. We are able to live a luxury life. We get a better looking products because of IP. New kind of mobile phones are coming to the market every month. It is because there is a desire, demand in the society. We want iPhone 12 गया नहीं, 13 आया, 13 गया नहीं, 14 आया, 14 गया नहीं, 14 Pro आ गया, 15 आएगा. This circle will keep on going because human beings want that. Now, we have justified that IP should be protected. Now, to what extent it should be protected? When we say that IP should be protected, we are saying, or we are advocating monopoly. हम कह रहे हैं कि monopoly होनी चाहिए. Is monopoly good? Of course, economists here will say, नहीं, this is going the wrong direction. There should be free and fair competition in the market. For example, if I am selling a lemonade, you should be allowed to sell a lemonade. He should be allowed to sell a lemonade. Everyone else should be allowed to sell a lemonade. And then what will happen? There will be free and fair competition in the market. Everyone should be allowed to enter into the market, exit the market whenever they want. But dear friends, from the point of view of IP experts, we are not saying that there should be an unlimited monopoly. What we are saying is that there should be a limited monopoly. And that is why, dear friends, in the later slides, when I talk about this, I'll say that IP should be protected for a limited period only. And in case there is a perpetual protection, of course, there are conditions which are to be satisfied in case, the protection has to be renewed. Is IPR a human right? Yes, we can say IPR is a human right because under the Article 27 Clause 2 of the Universal Declaration of Human Rights, it has been considered as a human right. IP does not find its place in the Indian constitution directly, but of course, Parliament has the power under Article 246 to enact laws relating to all these very IPs. Various types of IPs are there. We'll be discussing these very IPs in detail. But I want to talk about international treaties. There are international laws also, because some of you who might have basic understanding of IP, you might be aware that there are international treaties protecting intellectual property. There are domestic laws also to protect intellectual property. IP of a territory is protected by the domestic regime. Means, agar India ka IP hai, it has to be protected by an Indian law. Okay, we have Indian Patent Act, we have Indian Trademark Act, we have Indian Design Act, we have Indian Copyright Act, so on and so forth. We have multiple IP laws of India which are protecting the IPs in the country. Now, what is the need of international treaty? इसके लिए I'll share a small story with you. It was in, I think, mid of the 19th century, 1850s के करीब की बात है. There used to be trade fairs, trade exhibitions कह सकते हैं, in countries like Austria, France, Berlin. So in these very countries, Hungary में भी था. So what used to happen? People from all over the world, they used to attend such trade fairs and showcase their inventions. Machines hogi, devices hogi, they used to showcase that. But what the organizers started to note, that the participation declined, steeply declined. People were not ready and willing to participate in such international trade fairs. And when they try to study, अरे क्या reason है, why this has happened? Okay, give me a second. Huh? All right. So they found out that in different countries there was a different kind of a protection, different term of protection. In one country there was no protection at all. In another country there was 5 years protection. Another country had 10 years protection. Some had 20 years protection. So what will happen? You know, differential protection. It means that the countries where less protection is there or where no protection is there, anyone else can replicate their invention in those very countries without any kind of a fear. Okay, this brought the need of certain international treaties. Means there should be an international harmonization. Laws similar होने चाहिए, because IPs are so much trade centric. Mobile phone, you find a mobile phone, इसमें chip है, maybe chip is produced in UK, design is of China, assembling is in China, Japan का कोई chip है, some technology. So much of trade is happening all over the world that there is a need that there should be certain international harmonization. There should be certain similarity. Otherwise, what will happen? What happened in the 19th century will be happening in the 21st century also. Okay, that is why, to avoid that, international treaties are there. Paris Convention is there to protect industrial property. Berne Convention protects literary and artistic work. So what these conventions does, they give a kind of an outline. They gives a kind of a skeleton which our domestic regimes have to follow. And the examples which I was sharing, India has Indianized version of the Copyright Act, Trademark Act, Design Act. So here we have abided by the principles of these very treaties which are laid down in front of you. Let us now discuss about the fundamentals of different kinds of intellectual property rights, because I said that there are a lot of IPs. So let us talk about them one by one. First one is copyright. I've taken this as the first one because most of us have heard and are aware about a bit of about it. Copyright is a legal term describing rights given to the creators for their literary works and artistic works. What is protected? Original literary work, dramatic, musical, artistic work. Literary work means work of literature, article, writing, research comes in that. Dramatic works, drama, musical works, music, artistic works, painting, sculptures, etching, engraving, photography is protected by copyright. Cinematograph films, जो movies देखते हैं, these are protected by copyright. Sound recordings are protected by copyright. Computer programs, applications, softwares are protected by copyright. What is the term of protection? Protection is life of the author. जो बनाता है उसको हम author बोलते हैं copyright में. Life of the author plus 60 years from the date of death of the author. Okay, and where it is published like cinematograph films and sound recordings, it is 60 years from the date of publication. What is eligible for protection? Expressions of idea can be protected. Ideas per se cannot be protected. अब ये क्या चीज बता रहा हूं मैं? Idea means, for example, A and B fall in love with each other and lived happily thereafter. ठीक है? This is an idea. Upon this very idea, 100 movies शाहरुख खान ने बनाई होंगी, 50 सलमान खान ने, अक्षय कुमार, अजय देवगन. Thousands of movies have been created on this simple idea. But all these movies are copyrighted. How? Because idea has been expressed in different forms. For example, कुछ कुछ होता है में अलग स्टोरी है, परदेश में अलग स्टोरी है. So expression is different. Idea might be the same of love. Expression is different. Therefore, expressions can be protected. But that expression should be in material form. कहीं पे लिखा होना चाहिए, कहीं पे प्रिंटेड होना चाहिए, कहीं पे सेव्ड होना चाहिए. Therefore, अगर मेरे माइंड में एक पोइम है और आपने वो पोइम सुना दी, I will have no protection over it. Why? Because it is just in my mind. उसको फिक्सेट करना है मुझे कहीं पे. I have to put it in writing somewhere. And once I write it, there is a principle of automatic protection by the virtue of Berne Convention to International Convention हम देख रहे थे. There is no need to register your copyright. Therefore, आप article लिखते हैं, आप 99% no one goes for registration of copyright, because automatically once you complete your work, automatically it is protected by virtue of copyright. अब आप बोलेंगे सर प्रोटेक्शन फिर क्यों है अवेलेबल यहाँ पे, क्यों लॉज दिए हुए हैं? Because I'll tell you, there was a movie, I think Pathan or I don't know, Rais, कौन सी मूवी थी? The cost of production of that very movie was more than 300 crores. Now, when this much of investment is in question, you will not, leave it to the fate ki baad mein dekhi jayegi. You need to have some substantial proof that you are the owner of that very work, and you get that very evidence by virtue of registration, copyright registration. Okay, therefore, if you are working, creating something for commercial exploitation, you should always register your copyright. Otherwise, there is an automatic protection. It is not mandatory to register. There are moral rights and economic rights in copyright. अब moral rights क्या होता है? Right of attribution. If I have written an article, मेरा ही नाम होगा उसके ऊपर. No one can change or take away my name, and they cannot publish it under someone else's name. First thing. Moral right also mean that I have, my work cannot be distorted without my permission. Okay, I might have said something in an article, someone cannot distort my words and say, okay, this person said this. Okay, so this is the moral right. Economic rights are there, right of reproduction, sale, hiring, all these things are there. Some examples of some cases, very interesting cases are there. There is a monkey selfie case. What happened in this very case was that a group of tourists, they went into a jungle. A person was trying to click a selfie. Suddenly this chimpanzee came from nowhere, and the tourist got frightened, and the phone fell from his hand, and this chimpanzee somehow managed to click a selfie of himself. Now the question was, who will own the copyright in this case? There was a hilarious argument that this monkey should hold the copyright. However, it was rejected by the US Copyright Office, and they said that, see, non-human beings or legal entities, apart from them, animals at least, they cannot hold copyright. And another example is about this Roger versus Coons. On the left hand side, the black and white greeting card was there, which was scarcely purchased by anyone. No one purchased it, but suddenly someone created a sculpture which became very, very famous. It was very popular, but it was considered to be copyright infringement. Since we are academicians, one thing we must know about the concept of fair use, though it's a very detailed concept, but definitely I'll discuss it in a minute. Fair use means that you can use somebody else's copyright material for under certain conditions without seeking their permission. What are those very conditions? You must have heard, like for research purpose, for instructions to students, for academic purpose, you can use somebody else's material because हम किताब पढ़ रहे हैं. For example, in front of me, I have a book on intellectual property rights by Professor V.K. Huja. यही से पढ़ के मैं किसी को पढ़ाऊंगा. Okay, but that can be done because this is falling under the ambit of fair use. हम लोग research करते हैं, we write research papers, we quote other authors, we cite other authors. That is totally allowed. But of course, it should not be plagiarized. Plagiarism is against fair use. Plagiarism means that I am showcasing somebody else's work as my work when I will not quote. कोई पढ़ेगा वहां पे उसको लगेगा अरे ये तो इन्हीं ने लिखा है. That is wrong. That is unethical. That is against UGC rules, regulations which are there to prevent academic dishonesty. Okay, other many conditions are there of fair use, so that of course we can discuss some other time, but just for review, criticism, you can refer others' work. That is why you can write about a book in the form of book review. All these things are available under fair use. Let us talk about trademark. Trade and mark. before talking about trademark, let me ask you to imagine this very question in your mind and think about the responses. If I ask you, please go and purchase a toothpaste from a grocery store or a supermarket, 99% of the participants will either purchase Colgate, Pepsodent, maximum both. कोई आके पतंजलि वाले आ जाए या हिमालय, 2-3. Why it has happened in this very manner? Because people have attributed some kind of a quality or some kind of reputation to that very mark. Colgate का है तो अच्छा होगा, Pepsodent का है तो it will be good, it will not contain any hazardous material, it will not contain any toxic material, it is good for consumption, oral consumption also, and internal consumption also. Okay, we have faith in those very products. Johnson and Johnson product is there, we feel confident on using those very products upon our infants, our babies, no problem. Okay, so now what is a trademark? When I talk Colgate, perhaps I named certain brands. Trademark is a distinctive sign, and it's a sign which helps in distinction of one product or one service from the another product or another service. From this brand name Colgate, we can say, अच्छा Colgate brand का है, ये Pepsodent का नहीं है, right? And of course, ancillary, what happens because of that very brand, अब Colgate का brand है, it should not be disreputed or tarnished by some of their business practices. Therefore, they try to maintain that very standard. They try to maintain that very quality. Take the example of Apple. Every year they are coming up more or less with a new mobile phone, new model, and that is better and costlier than the former one, isn't it? So new and new, and that is happening. Why? Because they have a brand name. They have to maintain that very brand name. Okay, so what is that? Is it mandatory for a trademark to be registered? It is not mandatory for a trademark to be registered. जैसे आप देख रहे होंगे, आप the areas where you live, आप देख रहे होंगे people are running businesses under different names. दुकानें हैं, किसका मोहन लाल, whatever the name might be. So people can run the businesses under any name. There is no need to protection, no need to register trademark, but registration is always recommended for evidentiary value. There is a lesser protection available when trademark is not registered. Therefore, those who have a be it startup people or anyone who wants to do any kind of business, first and foremost recommendation is that they must mandatorily get their trademark registered. And before registration of that very trademark, they should do a trademark search, because my experience, I've seen many people out of jiffy, what they do, they think about a name, अच्छा ये बड़ा अच्छा नाम है, मेरे नाम से जुड़ रहा है, इसको मैं, they start their business, and after 5 years when their business becomes somehow popular, they find out, अच्छा अरे I'm not able to trademark this because of some kind of legal impediment. So therefore, always do this trademark search, always meet an expert, IP expert, get your trademark registered even before you start your business using any kind of a mark or launch any product in the market. If registered, there is what is the term of protection now. The term is, initially it is protected for a period of 10 years, which is subject to perpetual renewal. So after every 10 years, you can renew. After 10 years, you can renew your trademark. But again, certain conditions of use are required, which you have to substantiate. Now, in front of you, some different categories of trademarks are there. Brands are there, classmate, Nokia, symbols are there, tick mark. that oval is there of this Ford. Name marks are there, Levi's, Sony. Letter marks are there, Facebook, HP. P is of Pinterest. And you can just recognize a particular brand, particular company, particular association by just seeing their trademark. Numerals are there, 7 Up, 8 p.m., Formula 1, 1 Plus. Shape marks are there. Coca-Cola bottle is a shape mark. Zippo lighter is a shape mark. Combination of colors are available. Okay. Sound marks, sounds are also now registered as trademarks. Nokia tune is there. Dun, 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 dun. Immediately, if this very tune plays, everyone will recognize. Acha, yaar, ye to Nokia hai. So, see, it is this through by the virtue of this very tune or music, people are able to distinguish. अच्छा ये तो नोकिया का है. Next up, products mark are there. They are for various products. Cadbury के various chocolates are there. Services, Amazon services are there. Deliveries. Certification marks are there, which जैसे egg mark होता है, which shows that it is vegetarian agricultural product. Red वाला आप देखेंगे, it is for meat products. BIS hallmark is for is for gold. Wool mark is there. A lot of marks are there. Collective marks represent associations like Reliance is a mark. Tata is a big association, big company. So these are there. Even personalities, film personalities, they have registered their mark. Like SRK का अपना brand है, SRT का. Sachin, Ramesh Tendulkar, Shah Rukh Khan, Amitabh Bachchan, they have registered their marks. A lot of innovation is happening. Smell marks are also protected in other countries, not in India, but in other countries they are protected, like perfumes, fragrances. If fragrance is mixed with some rubber or something like that, golf ball, usme it is being there. Taste marks are also getting protection in other countries. As of now, in India, this hasn't happened with respect to smell and taste, but yes, about sound, it is permissible to register it as a trademark. Geographical indications. You must have heard about, first let me talk about the examples. You must have heard about Darjeeling tea, Mysore silk, Kashmir pashmina, Kani shawl, Fenies of Goa, Nagpur oranges, Tirupati laddu, Bikaneri bhujia, Gamosa of Assam. Many examples you must have heard. Some of you might be consuming some of goods which are represented by virtue of a geographical indication. Now what is a GI? Geographical indication is an indication. It's an indicator that a particular good upon which a GI is there, it has a specific geographical origin. And because of their specific geographical origin, it is getting some kind of a quality or reputation, okay, which is there because of that specific place of origin. It can be manufactured good also, like handloom textiles, which contain some human element, craftsmanship. It can be natural product, like I was saying, tea hai, mango, Alfonso mango, all these things. So these are very popular, but again the requirement is that it should have a quality or a reputation. चाय तो हर जगह मिल रही है, चाय तो मुंबई में भी प्रोड्यूस होती है, but again Darjeeling tea has a specific aroma, specific taste that is protected by virtue of geographical indication. These are community rights. ऐसा नहीं है कि मैं प्रोटेक्ट कर लूंगा, आई गेट अ दार्जिलिंग टी GI, फिर तो मेरी चांदी है. ऐसा नहीं है. It's a community right. The people who are the producers of that very kind of a good, they can get a license of this very GI as authorized user. So these things are also available. there is a huge, not only Indian market, but there is a huge global market with respect to geographical indication. Okay, फॉरेन में पीपल रिकमेंड अच्छा बासमती होना चाहिए, अच्छा कश्मीर का होना चाहिए, दार्जिलिंग की चाय होनी चाहिए. There is a huge market value associated with GIs. Indian government has launched various campaigns. There is a campaign wherein the logo has been redesigned and a slogan has been there, which is called as invaluable treasures of incredible India. Okay, which are these GIs. There are I think 432 registered GIs in India. I've recently heard that 33 new GIs have been registered in one day, thanks to the Honorable Prime Minister and the GI registry. And our Indian indigenous products will go to places, go all around the world with the help of GI protection, and it will benefit the community of those very producers who are producing those very goods. I know I have 5-7 minutes. I'll try to complete it in time. Next are industrial designs. I think I was saying that we all want better looking products in our homes. We want अच्छा वाज होना चाहिए, नया वाज होना चाहिए हमारे डाइनिंग रूम में या लिविंग रूम में. We want a mobile phone which should look unique. All these things are there. So this visual appeal is protected under industrial design. Okay, so industrial designs, they protect the shape, combination of colors, the patterns, ornamentation, aesthetic appearance of a particular product. Okay, this is protected by virtue of the industrial design. When we say industrial design, it means such kind of design is allowed to be registered which can be replicated by an industrial process. Okay, like for example, a kind of a mold is there. Through that very mold, things are produced. See in front of you, 37 designs are registered on this Tata Nano. Maybe one for this
Sorry
mirror.
to interrupt you, sir. Sir, you can conclude as per your convenient time. Don't worry.
Okay, thank you.
Yes,
Thank
sir,
you.
yeah.
Thanks. So, it protects industrial design. The purpose is to protect visual appearance because, you must be aware. Earlier, you must have seen mobile phones. कौन सा होता है 1100, Nokia 1100. Simple, भद्दा भी कह सकते हैं उसको. Simple looking mobile phone was there. Okay, but slowly and steadily, there was a shift in the human mind from substance to form. लोग ध्यान देने लगे, अच्छा भी लगना चाहिए, robust ठीक है, अच्छा भी तो लगना चाहिए. So that is protected by virtue of design. 37 designs are registered on this Tata Nano. Windshield का है, bumper का है, dicky, window, roof, tire के wheels, spoiler, lot of things. Okay, there is a bottle in front of your screen also. There is a bottle in my hand also. Multiple designs can be there on various types of water bottles. Design also helps in keeping a product alive. Otherwise, see, a simple pen is there. There might be 1 lakh designs of this very kind of a pen. Okay, otherwise pen would have there would be no scope of any creativity with this very pen. But yes, people want कोई sleek होना चाहिए, shine करना चाहिए, चमकना चाहिए, अलग वे में operation होना चाहिए. All these things are there. It can be protected by virtue of industrial design, and such a design has to be protected by virtue of by virtue of this very industrial design protection. The creativity is protected. It is mandatory that a design has to be registered. Without registration of industrial design, no protection can be claimed. Registration is allowed for a period of 10 years, which can be extended by a period of 5 more years. So in all, we can say 10 plus 5 years of protection is available. Examples, numerous examples are there in front of your screen. Another is semiconductor integrated circuit layout design. So before talking about this, I'll share one small example. Everyone owns LED lights, which we call as Diwali lights. किसी भी festival के साथ लगा लो, Eid, Christmas lights. Okay. If you'll observe that very light, next to the lights there is a small box. If you'll open that very box, you will find a chip, or we can say circuitry is there. जिसमें transistor, resistor, certain ICs are there. Okay, so this can be protected by virtue of semiconductor integrated circuit layout design protection, because because of this very circuitry, different functionality is there. Light कभी एक ऐसे चलेगी, अलग-अलग lights चमकेंगी in various patterns, various forms. The light will blink. Similarly, आप एक computer खोलेंगे, उसमें भी आप will find a circuitry. So this circuitry is protected. Nowadays, you will see Android software can now be put in a watch. So see how circuitry has changed. इतना बड़ा mobile phone. पहले laptop था. Laptop को they have abridged, compressed in the form of mobile. Mobile को भी compress कर दिया in the form of watch. अब now we never know. कल को एक wearable rings are also available. But so we do not know what future has in store for us. Okay, so though it is not a popular kind of a protection, in India only 2 ICs layout designs have been protected, because people prefer it that they remain a secret. Okay, so registration is mandatory for a period of 10 years. Once protected, it is available for a period of 10 years. After 10 years, it falls into the public domain. Patents. Patents are those very rights which are on an invention. An invention is protected by a patent. Now, what is an invention? Invention can be a product or a process which has to be new. Okay. First criteria is novelty. Second criteria is that inventive step. It should be more than a workmanship kind of an improvement or a workshop improvement, and it should be capable of industrial application. For example, if I'll say, we all have vehicles, 2-wheelers, 3-wheelers, 4-wheelers. If I say we take our vehicle to a mechanic कहता है अरे मैं इसका कुछ माइलेज बढ़ा दूंगा इसकी मैं. What he does, उसका fuel intake कम कर देता है. Can we say that उसने कुछ नया कर दिया, माइलेज तो 50 की थी अब 60 की हो गई है माइलेज. So can we say that he has innovated something new? No, it cannot be called as an invention. It cannot be patented. The reason is that it is just a mere workshop improvement. Okay. Now this is a pen. किसी ने ऐसा बना दिया पेन. मैं आता हूं, मैं इसको ऐसे कर देता हूं. मैं कहता हूं मेरा नया पेन आ गया. Can you get a patent over this? Of course no, because this is just a workshop improvement. This is obvious. Okay. So an invention should not be obvious. Okay. So inventions are given upon mechanical devices. It is given on some industrial processes like extraction of iron ore, extraction of some element. Many things are there. Technologies, for example, i5 technology, processing technology, i7, i9, these technologies, mechanical devices, all these can be protected by virtue of patent. So functional elements which provides a kind of a functionality, they are protected by virtue of patents, but provided that I told you the three essential criteria. One is that it should be novel, that is, it should be new, it should be inventive, it should not be obvious, and the third one is that it should be industrial application should be there. You should be able to replicate it. For example, अभी मैं कोई experiment करता हूँ, कुछ नया चीज बन जाती है. If I'm not able to replicate it, I won't be able to get a patent over it. Okay, so it is mandatory for an invention to be registered in order to get a patent. If an invention is not protected within time and reveal ho jati hai, then we cannot get a patent over it. The time period for protection of patent is 20 years from the date of filing of the application for that very patent. Now, with patents, there is a huge debate going on with respect to access to medicine. But what we say is that there is a kind of a balance, because patent is available upon, if we say drugs, only for a limited period, that is 20 years from the date of filing. But once they file for a patent, it takes some time for it to be granted. 3 to 4 years might be there, and but again, the point is that there is a huge cost which is involved, which I was talking about in the beginning. So therefore, there is a still justification that yes, a balance is required, but we cannot we cannot dismiss that medicine should be kept away from patenting. It cannot be done, it cannot be said so, otherwise no one will innovate, and innovation, a lot of research and development expense is required in order to create a single drug. This PPT on the screen, you can see that it is taking some around 10, 12 years for a drug to come into the market. So effectively they enjoy only 10, 12 years protection period only. Within that very period, you'll see that they have to meet their expenses also. But after 20 years, the drug comes to the public domain. In India, you are aware, we have a huge generic market. Cipla, Ranbaxy, इतने सारे हमारे पास generic giants are there. They'll come into picture after 20 years and they will replicate it. जो भी हम drugs use करते हैं, paracetamol, all these things are there. On these very drugs, there is no patent. Even government has started Jan Aushadhi Kendra, where non-patented medicines are available. Such medicines जिनका patent expire हो चुका है, those are available, because ailment तो expire नहीं हुई ना, ailment is still there. So always it is recommended you should try to purchase drugs from such Jan Aushadhi Kendras, and you should try to purchase generic drugs. You should always ask your doctor, please prescribe me generic medicine. Otherwise, what will happen? Some might have, not all, some might have some kind of a commission. उसमें में वो चलता है उनका system. Trade secrets, very interesting trade secret, because I referred to it. I used one name, trade secret, in between. Trade secret means a secret which is of commercial value. Trade hai to commercial value, secret means a secret, and a secret remains a secret till it is a secret. If it is revealed, it is no longer a secret. And a very typical example, which is everywhere, any IP expert you call, they'll tell you about this very example of Coca-Cola. Coca-Cola is a soft drink which was invented very, very long ago in 1886. but it was not patented, because if it is patented, it means the formula has to be disclosed. Nevertheless, they never protected it and continued protection, and kept it as it is a secret only. Um, and till date, only two people in the world who belong to, of course, the Coca-Cola family only, they know about this process of making Coca-Cola. It is a trade secret, and these two people, they never travel together. आप समझ लीजिए, a century old business, still only two people know about it in the whole world, and it is to that length they have protected their secret. And so only two people are aware about it. They do not travel together, because same flight se ja rahe hain, crash ho gaya, dono mar jayenge. So just to avoid that, they travel separately. Okay. So we all say that Coca-Cola has a very unique taste which no one has ever replicated. So in the concluding terms, I again say that when we talk about intellectual property on a particular product, it is not that one product will have only one IP. Example is in front of your screen. शूज किस ब्रांड का है? नाइकी ब्रांड का है. ब्रांड इज प्रोटेक्टेड बाय द वर्च्यू ऑफ ट्रेडमार्क. द लुक इज प्रोटेक्टेड of this very shoe by virtue of design. Maybe there is a technology in that very shoe sole, or the material of this very shoe is protected by virtue of patent. And copyright, of course, protects the artwork. Nike के advertisements होते हैं, these are protected by virtue of copyright. So I mean to say is that multiple IPs can be there on a particular product. एक सिंपल पेन है, इस पेन में maybe टिक टैक मैकेनिज्म जो है, it can be protected by virtue of patent. इसका जो डिजाइन है, look is protected by virtue of design. इस पे ट्रेडमार्क हो सकता है, many things. Its ink can be patented also. So its advertisement can be protected by virtue of copyright. So this is it. Some questions are there in front of you. Which of these are inventions? Cloud, car, video game, alarm clock, fossil. Now cloud is something which already exists. We have not invented it. Okay, it is not an invention. Car, yes, we have invented it. It can be invention. Video game is a software program which is protected under copyright. Fossil is already is a natural resource. It is not invented. It is already there. Alarm clock, yes, we can invent alarm clock. Certain trademarks are there in this very Sudoku kind of puzzle. You can just name some. On the first column, Pepsi is written. Okay. And in the first row, you can find Amul. And similarly, you can screenshot this very puzzle, and you can maybe in your free time, find out what more trademarks can be there. Point is that, why I said, because we recognize these very trademarks so much. Why is IP important to us? In a nutshell, to safeguard new and exciting inventions, protects jobs, creates jobs. Okay, it creates job. New product is there, new jobs it will create. Stronger economy, because if product is there protected by IP, it will be commercialized. A lot of GST revenue will be generated, licensing fees, etc. So economy will grow. We also want to have some products which becomes our favorite. We want unique products. It helps us find our favorite products. It helps authors, artists to be rewarded for their work. So of course helps household items to be useful and look good. So we might have things which are there in our household, but we all want new looking things all the time. So that is why, dear friends, IP is very, very important. Dear friends, if you want to know more about IP, you can visit these resources. There's a website of World Intellectual Property Organization. You can visit that, wipo.int. There is a IP website of India itself, of the government of India, ipindia.nic.in. There are website of various other registries like semiconductor and IC registries there, corporate registries separate. Um, if you want to know more about some legal affairs, legal happenings, you can visit www.lawlex.org. So you can know about it. And one thing I want to share is that tomorrow, 26th of April, is the World IP Day. So annually, internationally, this IP Day is observed. And this year, the theme is Women and IP, Fostering Innovation and Creativity. So I must congratulate the whole management of Bhavna Trust College for organizing such a wonderful session on this at a very apt time, a day before the World IP Day. So, all congratulations to all the organizers, all the teams who are involved. But yes, now I'm open for some questions. Yes, someone has responded. Cadbury in the second column. Yes, of course, a lot of trademarks are there, and trademarks they mold our choices. Okay, if we see something in the advertisement, हम चाहते हैं अरे ये नया आया है, we'll try this, we'll purchase this, ये अच्छा है, बुरा है. So trademark takes along with it some kind of goodwill also, right? But anyone, those who are from science backgrounds, who are involved in some innovation, creativity, my suggestion to them is that, before, if you have created something, do not just like that disclose it to everyone or publish it without just like that, because if you'll do that, what will happen? Your novelty will be lost. तो इसीलिए first file patent protection, only then go for revealing or publishing about your work. Okay, and even with those people with whom you are discussing about your work, always sign a non-disclosure agreement with that very party. Okay, because there have been many cases wherein the ideas, not ideas, I'll say, the innovation have been stolen in that very manner. Yes, Anisha. Yes, Anisha, Mitesh, you have a question? You can please ask directly.
Sir, I wanted to know, sir, while the exam for patent agent exam, which is going to conduct now in May 7th, for that, when you have already, we have given the syllabus, what should be studied. But in that, sir, the drafting part of the innovation, when it comes to draft the innovation, the claims, provisional specification and complete specification given, is there a requirement for drawing in that? The invention should be, if the scientific invention given to us is not an invention which require any physical features in it, drawing is a must provision, or it is a mandatory, or it is just
drawing is not mandatory, but the controller can ask for a drawing also. See, the point is that when we talk about patent, the purpose is that full disclosure should be there. Okay, so if the claims have been written in a manner that we are not able to conceptualize what is actually the product or process which is to be protected, their drawing can be asked, which can at the will of the controller be considered to be part of the specification also. He can ask for models, he can ask for specimen, all these things might be asked. And for more clarity, nowadays we have seen a trend, drawings are there. And if you want to know about claim drafting, you can just visit the website of there's a patent search engine of the IP India only. There you can just put any you know what we can say patent number and all. You can download all the material, so it is available there.
Yes, sir.
Know
Thank you
about
so much.
yes. Yes, any more questions? Yes, Shailesh ji.
Good afternoon, sir.
Very good.
Indeed, a very informative session. Sir, just now you have referred about a product or a process patent. Can you please explain more about that and which one is applicable in India?
Very good question. Before India became a signatory to TRIPS agreement, that is 1995. Before 1995, only process patent was there. A process patent kya hai? I'll give a simple example. A plus B is equal to C. A plus B is the process. C is the product. Earlier, only you could have protected before 1995 A plus B. Someone else could have arrived at C by adding X plus Y. तो A plus B को भी process patent मिल रहा था. Secondly, X plus Y को भी process patent मिल रहा था. But after India signed TRIPS agreement, there was a requirement, a mandate from TRIPS that India had to add product patent regime. It means now both you can have a product patent also plus process patent also. You can have A plus B is equal to C. So you can have protection of A plus B also, and you can directly protect the product C also. So now the protection is more rigid.
Thank you, sir.
Most welcome.
Good afternoon, sir. Good afternoon to everyone.
Yes, good afternoon.
If anyone is having any question, they can write in chat box. There is a network issue, so you can drop your questions in chat box.
If no questions are there, we can conclude also.
Sir, in chat box there is no questions. If any, I will read it out. Sir, one question has come. Some brands are banned in other countries
Yes.
due to quality issue, but still sold in our country. How it's work?
All right. It has nothing to do with intellectual property. Okay. So, there are various rules which deals with quality assurance. Okay. Like food ke liye there are FASSSI license. For other products like industrial products, ISI marks are there. So that has nothing to do with the IP. Okay. But anyhow, different products like, for example, Samsung and Apple. So that variation will always be there. Okay. So point is that there should be choices. There should be competition in the market. If we say sir Apple ही को allow करेंगे हम, तो won't it be unfair? Because everyone won't be able to afford Apple, isn't it? So quality control and other things, those are dealt under different regulations.
Okay, sir. Any other want to ask the question? They can drop their question in chat box.
Sir, I feel there are no more questions. So thank you for an informative and lively session. The conceptual explanation with examples were wonderful. And I'm also thankful to the management of Bhavna Trust Junior and Degree College of Commerce and Science for conducting this webinar. I extend my sincere thanks to Honorable Chief Guest, Mr. Sajid Sheikh. I'm also thankful to our principal, Dr. Aruna Singham, for her unwavering support for making this webinar a success. I'm also thankful to teaching and non-teaching, and a special thanks to IQAC and IPR cell. Last but not the least, special thanks to the audience and students of Bhavna Trust Junior and Degree College of Commerce and Science for their patience listening. Let's conclude the webinar with the slogan Celebrate Creativity and Innovation. Now, I would request you all to stand for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे जन गण मन अधि
I would request everyone to fill the feedback form for the e-certificates to be generated, and the link will be shared in the WhatsApp group and also in the chat box. With the permission of our principal ma'am, I declared this program as closed. I would request everyone to leave the meet. Tons of thanks.
Thank you, ma'am.
All, thank you.
Thank you. Thank you, sir. Thank you, ma'am.
Thank you, ma'am. Thank you, sir. Thank you.